purpose of a GMC Fitness to Practice hearing is to decide whether the doctor's fitness to practice is impaired, and if so, whether action should be taken on his or her registration. A case only reaches a fitness to practice hearing after a lengthy investigation by the GMC into the complaint against the doctor. Just a very small proportion of the thousands of complaints made each year end in a fitness to practice or FTP hearing, though that's no comfort if you're the one facing an FTP panel. FTP hearings are held by the Medical Practitioners Tribunal Service, MPTS, an operationally separate part of the GMC based in Manchester. The GMC brings the case against the doctor and the MPTS adjudicates it. There can often be a long delay between the investigation and the panel hearing, during which time the GMC may carry out more investigations and seek expert evidence. The MDU may also seek the opinion of an expert witness to support the defence case. An FTP panel consists of a minimum of 3 panellists, at least one medical and at least one lay member, and a chair who can be medical or lay. A legal assessor attends to advise on points of law or on the procedure and powers of the panel. There may also be specialist advisors who advise the panel on the medical significance of information relating to the doctor's clinical performance or health. Unless the panel is considering information solely about the doctor's health, the hearing is normally held in public. Anyone can attend, and the press may also be there for high-profile cases. The fitness to practice panel must go through 3 stages. First, hearing all the evidence. Evidence is presented by both sides, and both the doctor and the GMC can call witnesses. Lawyers for each party will cross-examine the witnesses, and panel members can also ask questions. Once all the evidence has been heard, the panel determines whether the facts of the case have been found proved on the balance of probability. If the facts are found proved, the panel must decide whether the doctor's fitness to practice is impaired. The panel takes into account not only the facts, but also other factors including evidence of the doctor's insight into what happened, remediation or recovery, and any other evidence relevant to the doctor's current fitness to practice. The FTP panel recognises that a good doctor is not someone who makes no mistakes at all, but someone who learns from their mistakes. They like to see evidence that the doctor has learnt whatever lessons needed to be learnt from what happened. If fitness to practice is found to be impaired, the panel may accept undertakings offered by the doctor or apply a sanction. Of the possible sanctions, conditions or suspension are the most common. The third, erasure from the register, is applied very rarely and only in the most serious cases. It is never used when the impaired fitness to practice is solely a result of health issues. The doctor has the right of appeal against the panel's decision. The appeal is made to the High Court or the equivalent in devolved jurisdictions. The Professional Standards Authority also has the power to appeal against MPTS decisions in the interests of public protection if it thinks the sanction is unduly lenient. However, this power is rarely exercised. If the doctor's fitness to practice is found not to be impaired, the panel will usually take no action, although it can issue a written warning depending on the circumstances. At the end of the hearing, the chair will read out the panel's decision and the panel secretary will provide written notification. If the case ended with a sanction, this will appear on the GMC website. In all cases, a copy of the determination will be published on the MPTS website, although information about the doctor's health is not included. If you receive notification of a GMC complaint against you, it's vital that you contact us as soon as possible.